Now, Mr. Klug, you're no longer a stockbroker, right?
That's correct.
You're now working in real estate?
I'm a realtor, yes.
And while you were a stockbroker, there are times that you would make trades without a
I'm
client's...
objecting, Judge. We addressed this in a pretrial motion.
Sustained when we did, so we're not going to go into it.
Your Honor, I'm not going into those things.
You're going into it.
From 2013 to 2015, you worked with a woman named Shelley Burnt.
I'm objecting to the relevance of this testimony. If some other witness is going to be called, then that's relevant. But in terms of what Mr. Klug has to say about that, that's not relevant.
What sort of relevance are we trying to establish?
This is prior acts of untruthful conduct.
Judge, this was the subject of a pretrial
On the
motion.
back, folks.
All right, here we go. We might see crotchety Judge Anthony Milasowskis lose his beep on this attorney. We've been waiting for this. This is going to be interesting. This is where you see Milasowskis get very, very stern with attorneys.
Jury is outside of the courtroom. I thought we had a motion hearing and I said nothing's coming in, and suddenly it's all coming in.
Your Honor, that was about the FINRA documents and the 2016 criminal case, with neither of which I have asked about at this point. What I am planning to ask about is what I have a good faith basis to believe that Mr. Klug would make illegal trades where he needed a signature to make those trades, and he would do those without a signature or have his secretary forge signatures.
Sounds like another act.
So,
Don't you don't say anything. Sounds like another act, should have been brought up so we
Your
could have discussed it.
I believe this is it's not an other act. It is a instance of prior untruthful conduct for which I do have to accept Mr. Klug's answer. I do not get to impeach upon it.
Sounds like another act.
So, Judge, I believe that Ms. Burnt was mentioned in their pretrial motions, and this is part of what the court denied. Am I incorrect about that? I
Thought I
remember.
signed an order to that effect.
I don't believe there was anything about Shelley Burnt's testimony.
Yes,
in
there
that.
was. Shelley Burnt was in the pretrial motion. I looked at it this morning. She's listed in the pretrial motion.
We're going, we're not supposed to.
I understand the court's ruling.
Well, we had a hearing about this. We discussed it. I signed an order, and I'm always amazed when we get in a trial, people still try to get in evidence that's been denied.
Judge, Attorney Krause, my concern is that this is specifically about the untruthful conduct of a witness, which
Should have
is
been
not,
brought up prior to all this.
it's not specifically an other act.
You're trying to get it in a back door.
We're not trying to get it in a back door. This is information that the prosecution has. This is not a back door.
It's not
They
coming.
have this information.
It's not coming
Judge.
in. It should have been in a pretrial motion.
Under 90608, we have the ability, we have the right to cross-examine a witness under sub 2 and sub 1 about their characterful truthfulness, and that's what this is.
Well, we had this massive motion hearing, and we talked about all these issues.
The only thing that was talked about was FINRA and that one prior conviction,
We
which
talked about more than that.
not as it related to Mr. Klug.
I believe that we did. If we pull up the defense motion, it specifically references Shelley Burnt and what she would have to say about Mr. Klug. So I don't know why we're debating what's in writing.
I agree.
Where in the signed order does it say that we cannot go into Mr. Klug's untruthful character?
I'll look it up.
We had a motion hearing. It was all brought up. I signed the order, and now it's not coming in.
So the court's not going to allow the defense to cross-examine this witness about specific instances of untruthful character.
Well, you should have brought it up when we discussed all these other acts.
Judge, I'm just asking a question so we can clarify the appellate
You're
record.
not going to get an answer that you want.
I just want to know if we can cross-examine.
You understand that?
I do, Judge.
You're not going to box me into something.
I'm not trying
I'm not going to play that game.
I'm not trying to do that.
You
Judge.
are.
I'm just trying to clarify because there
I
are.
told you we had pretrial motions.
Judge, I want to know.
You
so
were
that-
here.
I know I was.
So was Miss Renner.
I want to know for when we call witnesses. So I need to clarify this so I can determine.
Maybe look
whether
at the order I signed in the motion you filed. I had a chance to review everything on the issue of Mr. Klug as to what Miss Renner was trying to ask and what Miss Krause was asking me. Here's the record. 2016, a motion was filed, and we heard this motion November 21st, 2022. It says, defendant's motion to admit specific instances of conduct of Edward Klug. It's signed by Miss Renner. On page 5 of the motion, it says we're going to talk about two different evidentiary reasons. One, other acts, also 90608, which is character and conduct of the witness. So we had the motion here. And thank God the transcript is in front of me. Usually it's not typed up that fast. And what does the transcript say? This is Miss Renner. Page 36. Your Honor, under the rules of evidence, we're also able to get into specific instances of untruthful conduct. And we went through all the facts of the untruthful conduct, the financial dealings. The allegation was he was signing documents that clients didn't know about. He was doing all this illegal activity. We argued it. I basically said there was nothing there. There was a complaint filed by some client that it was going through a divorce. There was no IRS issues. There's a board for brokers. They never found him guilty of anything. There was nothing. So then we all decide, well, let's put that in writing. Let's put that in the order. So I got two orders. I got one from the defense. I got one from the state. This is the defense's order. Number 10, in regards to the defense motion regarding Edward Klug, the defense is precluded from questioning Mr. Klug about the FINRA allegations, but may question him regarding some criminal allegations, and that issue went away. So this is your order saying you're not going to be able to get into it. Don't interrupt me. And then we got the state's motion, their order. Page 2 of the order I signed. Besides the defense's order that says we're not going there, their own order. It says defendant's motion to admit specific instances of conduct of Edward Klug filed on November 29, 2016 and July 31st of 2017. The court denies these motions for the reasons stated on the record. So we got two orders saying we're not going to get there. And what does the defense do? Goes right to that area. And what does the other counsel do? We'll explain your order, Judge. It's in writing. It's part of the record. It's here. It was denied. It was heard. Now, if the state had done something like this, the defense would be screaming. That's the problem sometimes with cases. The state can't appeal some issues. The defense can. So it should not have been gone to. It's in the record. And I'm shocked that you're telling me, well, wait a minute, Judge. That's not what the order says. Look at the statute. Read the transcript. Have a good lunch. We'll see you at 1
Your Honor,
o'clock.
may I make my record, please?
We're going to lunch.
What time are we due back, Your Honor?
1 o'clock.
Thank you.
Judge, at some point, can we talk? In chambers. Judge.
I don't know if the jury's gone, so hang on. They're all gone.
Or they're staying.
Okay, he can go. Thank you for reminding me. Well, let's have the defendant go.